Yes, Mr. Skinner.
My lords, my lady, I propose to address the court, subject of course to any other way you'd like me to do it, in 4 sections. First, I propose to just outline the respondent's case in very short summary. Second, I want to deal with the legal framework. I'll try and do that as briefly as I may, given the number of authorities to which the court has already had its attention drawn. Although I'm afraid there are a couple of others that I do need to take the court to. Third, the facts. And fourth, our response to the grounds of appeal. Dealing then firstly with the respondent's case in summary, this is, in my respectful submission, a pretty straightforward case which the judge approached in an entirely conventional and undoubtedly lawful manner. The reality of what took place here is as follows. The Labour Party, when it wasn't in government, made a pre-election commitment to repeal minimum service levels, what have become known as MSLs, across the board, not just in relation to the Home Office. They won the 2024 general election on the 4th of July, formed a government shortly thereafter. In accordance with that the pre-election commitment, MSLs as a whole are in the process of being repealed, and an undertaking has been given not to use the powers that they consider inappropriate in the interim. As I think the court's already been made aware, the process of repealing the MSLs is part of the Employment Rights Bill, which is currently before Parliament. Plainly, a bill of that size that makes the difference that it makes to the law isn't something that can be done immediately on coming to power. These things take time. So it's no surprise that the way in which the government addressed what it viewed as an inappropriate piece of law, namely MSLs, was put it in the Employment Rights Bill and undertake not to use the powers in the impugned regulations until then. And it's obviously done these things because the government's policy, as it is now, and the Labour Party's policy, as it was when it was in opposition, is that the MSL law strikes the wrong balance between the rights of trade unions and their members on the one hand and the public interest on the other. That is, I will be submitting, a very far cry from a policy or a position that MSLs are in and of themselves a breach of Article 11, as the claimants had alleged. The claimant's focus before this court has, and in fairness in the submissions to the judge, has to a large degree been focused on the fact that they've succeeded in obtaining what they wanted in the litigation. But it's important to recognise that that's not in dispute. The defendant has at all times accepted that the claimant has achieved the outcome it sought in the judicial review. The question for the judge, and I'll take the court to the submissions in due course, but the question for the judge that was put in issue by the now respondent and defendant was whether or not that success was caused as a result of the legal merits or of the fact of the claim. And respectfully, in my submission, it departs from reality to suggest, as I think the claimants must...
Sorry, could I...
Of course.
I was trying to write this down. You're going quite fast.
Oh, I do apologise, my lord, of course.
Was it caused by legal merits or the fact of the claim?
Or the fact of bringing the claim.
The fact of bringing claim, thank you.
Yeah. And my submission is going to be that it departs from reality to suggest that had the claimants not brought their claim, the current government, when it came to power, having made a pre-election promise to repeal, having made a pre-election promise to repeal the law, would, had this claim not been on foot, not done so.
I know you're in the middle of an important introductory passage, but what do people have to do in this situation? Keep an eye on the opinion polls before they sue?
Well, the claimant in this case, the nature of, it depends on the nature of the challenge to some extent.
Yes.
Because obviously if you're challenging, say, an individual immigration decision that's taken pursuant to a policy that a government has said, or an opposition party, has said in opposition that it's going to repeal, in case that doesn't happen quickly enough or whatever, you can see that somebody might bring a challenge. That's rather different to the ab ante challenge that was brought here to the power to issue work notices. There was no challenge in this case to any particular decision to issue a work notice. In part, that's because no such decision was ever taken under these regulations. And effectively, a claimant in judicial review who is seeking to challenge a piece of secondary legislation on which they know is likely on all accounts to be repealed if a particular party comes to power, takes a risk when they bring their claim.
Well, why? I mean, that begs the questions, it seems to me. View it as of the date when proceedings were issued, March 2024. You wouldn't contend, would you, that the state of opinion polls at that time is relevant? So at that time, the PCSU wanted to challenge the lawfulness of the secondary legislation. They couldn't challenge the lawfulness of the primary statute.
Well, say that it was a human rights challenge, so they could have brought a claim under the Section 4 declaration.
The government would have said, well, that's very interesting, but you can get lost. Anyway, they can and did challenge the regulations. What else could they do? Supposing the Conservative government had been re-elected, then the case would have gone to trial.
Yes, of course. I think the example of a change of government over the course of a general election is potentially the thin end of the wedge in a sense, because obviously the same government can, for reasons unrelated to a particular piece of litigation, change policy if that's the view that's taken. Money, the financial situation changes, whatever.
Yes.
There can be all sorts of policy reasons, and the same approach applies in those cases as is the one that I'm advocating for today. That if there's a change of policy unrelated to the litigation, then the fact that that has been undertaken means that the normal order is that a claimant will get no orders to costs in their judicial review claim.
Well, why? How do you let's stick with this scenario that the incumbent government, as I recall, the election could have been any time up to December, but it wasn't known in March that it would be in the summer. But anyway, the incumbent government, for whatever reason, decides not to fight the claim. You say if it's for a policy reason, then the claimant gets no costs.
I say if it's for a reason that's unrelated to, or that's not caused by either the fact of the claim or the merits of the claim, so that there's no causal nexus between the claim and the achievement of the result. I mean, I'll take court, of course, to the authorities in due course, but that's the submission. That if there's no, and of course we're in an area of deep discretion, so it will depend on the facts of the case. But the authorities establish, my submission will be that where a claim has become academic because of a reason that is extraneous to the fact of or merits of the litigation, the normal order is no orders to costs. Of course, that can be departed from.
Could we just clear away some ground, which I think you have been doing in your submissions and answers? The opinion polls are not relevant. Correct. The change of government is not relevant.
It's not itself relevant.
No.
It, of course, provides the background.
The government is the government.
Yeah.
I mean, of course, it leads to the issue arising.
In this case, the change of government explains what I will say about the change of government is that it means that this isn't a case like Bacta, where there was no background information.
Sorry to speak. But the respondent is the same respondent at the end of the claim as at the beginning.
Yes.
And the third thing I think we might clear away is that the date of the final hearing is not of itself relevant. So that, for example, if the general election had been in November and the final hearing had been a few days afterwards, unless there was some particular magic arising out of the juxtaposition, the date of the final hearing doesn't really matter either.
Correct. I mean, it might, of course, matter practically to what happens to the final hearing if it's immediately after the election.
But so, for example, if the final hearing, unlikely though it sounds, had been listed to take place in the second week of August, rather than in the first week of December, that doesn't materially alter the situation.
Not as a matter of principle.
No. Thank you.
I think the submission that I just made before those interactions was that it's plain that the government would have done, but for this claim, exactly as it did do. And my submission is going to be that the judge was accordingly well entitled to find that there was no causal nexus between the claim and the outcome which the claimants achieved, and accordingly entitled to reach the decision he did. And given that the way in which this issue was the central issue before him on the basis of the submissions that he had, he was entitled to give the reasons that he did for the decision that he reached.
Doesn't this take us to the nub of this? You say it's plain that the government would have done exactly what it did do. But that has got to be provisoed by the fact that it was going to be a Labour government. And that was not known in March, that it would be such a government, and it was not known when there might be a choice of government. So it doesn't that require some explanation?
I can see that there might have been potential arguments before, there might in principle have been arguments put to the judge that the claimants should have been entitled to their costs up to a certain point, or potentially their costs of, for example, if this letter, the 6th of August letter from the Minister, hadn't been sent, and instead a holding response from GLD had said, we're not giving any undertakings, the Ministers are considering what to do about all of this, and we're going to carry on fighting the claim until, and we expect you to incur the costs of continuing to fight the claim until we've reached a policy position, then I can see that there could in principle be arguments about the costs that were incurred in that interim period. But on the facts as they are in this case, in my submission, as soon as, well, the relevance of the change of government is because it does show that there was no causal connection between the claim.
What would your response be to, as you say, a different application to say, well, we'll have our costs please up until the general election, or we'll have our costs please up until the 6th of August? What response could you give to that?
Well, if I can give two. The first is that wasn't the submissions that were made to the judge. But the point still stands that there's no causal, the authorities in my submission established that causal connection is a necessary, if not itself sufficient, reason to award costs to somebody that achieves what they sought in the judicial review. And given that what they achieved was not as a result of bringing the claim, that the point still stands. I mean, my answer effectively is the cases say that causal connection is a necessary but not itself sufficient aspect. The judge was entitled to apply the authorities that were put before him, which he did. And of course, I mean, I'm going to come on to the proper approach of an appellate court in relation to costs in due course, but of course it may be that there are other costs orders that on the facts of this or similar fact patterns could have been made equally lawfully, but that doesn't of itself impugn the lawfulness of the order which the judge did make on the basis of the submissions which he had in front of him, which were in the normal way limited to the key points that the parties wanted to put before him, I appreciate that we've got into the sort of meat of the facts. I did want to deal with the law first, because I think if we deal with the legal framework first, it makes dealing with the facts just a little bit easier. The way I propose to deal with this is just to give you a list of propositions and the authorities that make those propositions good. I don't think, speaking for myself, I didn't think that the court would be assisted by a second trawl chronologically through the authorities. So there are, I'm sorry to say, 11 propositions, but I think they're all pretty discreet.
Right.
And some of them I think are totally uncontroversial, and but just need to be made in order to make good the kind of sequence of logic. So the first proposition is decisions in relation to costs are highly fact sensitive and very much a matter for the discretion of the judge. If authority is required, it's Croydon, paragraph 1 and paragraph 65. Paragraph 65 was the one that Lady Justice Elisabeth Laing read to the court earlier. The second proposition is that a decision on cost... excuse me.
If you're doing 11 points...
No, of course.
And you're expecting us to write them down, you have to go a bit more slowly.
Of course. I do apologise.
Right.
The second proposition is that a decision on costs where a claim has settled will only be made if it is proportionate to do so. And for your note, the authority for that is, it's in Croydon at paragraph 47. That's page 107 of the authorities bundle. And that's also made clear by the judgment of Lord Justice Males in Parveen, paragraphs 38 to 42, which the court has already looked at. Just while I'm on this point...
Sorry, do you mean a decision on costs or a decision on the merits?
No.
Because the court has got to make a decision on costs.
No, a decision on the costs will only be made where it's proportionate to do so.
Well, do you mean any decision, or
yes,
a decision to award
no,
somebody their costs?
So a decision where the process of considering what the right answer to the cost question is disproportionate.
I see what you mean. Yeah.
The court will order no orders to costs because it's a disproportionate process that it has to go through.
A decision to do anything other than make no orders to costs. And it's got to do something. It can't just be left hanging in the air.
I suppose the reason I didn't put it quite like that is because obviously one of the things that the court might then do when considering what the appropriate costs order to make is make no orders to costs. But the point I was making is just that that's the default if the process is a disproportionate one.
Right.
That's not engaged in this case.
No, it's not. And I should. Well, there are some other things that flow from that, so which are potentially engaged in this case. So, which is why I make the point. I accept that the dicta to which Ms. Apps referred to the court as to the need to not too readily resort to not bothering to make an analysis on the merits. I accept that that's right. That's not a legal principle, though. That's just the court shouldn't be too willing to adopt the default position and not analyse the facts. My third point, well, there are 2 points that flow from that, from the discretionary nature of the decision and the need to deal with costs in a proportionate manner. These are my third and fourth propositions. The third point that flows, the first that flows from the first 2 points, is that the duty to give reasons for costs is a highly attenuated one. There are 2 authorities that, at least one of which I need to take the court to. I appreciate that the court will be probably well familiar with English and Emery Reinbold, but that is the authority in this area. Now that is at it's page 19, tab 3 of the authorities bundle. That authority deals with reasons that the duty to give reasons on behalf of judges generally, but one of the appeals in that case was a costs appeal, and is helpful for that reason in particular. The appeal that was a costs appeal is the case of Verrecchia, is the appeal that was, and the facts are to some extent summarised in paragraph 4 on page 24. And the point to note in particular is that the judge made no order as to the costs of the proceedings, and he did so without explanation. Just taking the authority in its paragraph order, if I may, at paragraph 14, over on page 27, the court held that often no reasons are given for costs decisions. Such a practice, we believe, can only comply with Article 6 of the European Convention if the reason for the decision in respect of costs is clearly implicit from the circumstances in which the award is made. And a few lines further down, where the reason for an order as to cost is not obvious, the judge should explain why he or she has made the order. The explanation can usually be brief. That theme is then picked up again in paragraph 30 on page 30. Effectively makes the point that no explanation can be acceptable, no reasons can be acceptable where the court can draw the inferences to the basis for the decision. My words, not the learned judges. And then, if one turns to paragraph 9
further, because it says where no express explanation is given, appellate court will approach the material facts on the assumption the judge will have had a good reason for the award.
Right. If we then turn to this court's analysis of the Verrecchia case at paragraph 91 of the judgment, that's at page 39. And it may just be helpful to see what happened sort of in a little bit more detail here. We had at paragraph 96 on page 40, we see that what happened is that a draft judgment of the decision on the trial was circulated to the parties, and that had the last paragraph of that draft judgment said no order as to costs, full stop, no explanation. The court then says, well, that was clearly a provisional view, because he then decided that the costs should be dealt with by written submissions, and he didn't and couldn't have known at that stage of drafting the draft judgment that there had been various offers made. We then see paragraph 98, counsel submitted extensive written submissions. Position taken by the claimant was there should be an order in its favour. Police said there should be no orders to costs. Judge's decision is then cited. I've considered the submissions and all the authorities cited. In all the circumstances, I'm unpersuaded that I should vary my order that each party should pay their own costs and that there should be no orders to costs. And then, of course, at 99, this court says the judge has not, of course, made any order which could be varied. So what he must have meant is I'm unpersuaded that my provisional view was incorrect. And we then get I won't trouble the court with the submissions that were then made to this court, but the conclusions start at 109 on page 42. And if I could just ask the court, please, to read 109 through to 112.
Yes.
And the point I would make is that it's clear from that consideration of the judge's short reasons that this court held that effectively reasons that are as short as the judge's, which refer back to the submissions that were made to him, are sufficient in relation to a question of costs. The second authority on reasons is Parveen. I appreciate that we've already
That
been...
was the case, was it not, where, I haven't absorbed it enough to know, but the judge had handed down a substantial judgment.
Yes, although that's right, although the costs, the submissions that he referred to in the judgment on costs are the submissions on costs.
Yes, but I mean, in a sense, you know, as far as I'm aware, the only engagement that the judge in this case had with the proceedings was the order for costs. That he
Correct.
Yes.
Well, I don't know how long the trial was, but you know, there was a great deal in issue. The claimant had made an offer to settle for some six-figure amount. The police had paid £5,500 into court, and the claimant gets £37,500. Judge who's heard the trial says no orders to costs. Mr. Justice Steele, who's in a rather better position than a judge. No criticism of Judge Jarman, but he's considering a case on the papers with very brief submissions from each side.
Yes, I'm not relying on this to draw any real comparison between the exercise that the two judges had to go through. The point that I draw from this is simply, firstly, the statements of principle as to what is required in relation to a costs decision, and then simply to make the point that the example that the judge gave there was held to be sufficient. Now, I'm not suggesting that it follows as night follows day, that means that any costs decision of that length is lawful, but it is an indication that in an appropriate case, a costs decision of that length is not going to fail the duty to give reasons test. The second authority is Parveen. I appreciate that the course has already been taken to this. There are just it's paragraph 46.
Is this your fourth point, or are you still on it?
No, I'm still on the third point, which is that the duty to give reasons in relation to costs is a highly attenuated one. That's my language. That doesn't derive from the case law, but effectively it's a low-level duty. Might be another way of putting it. But the reason I take the court to Parveen is just in relation to paragraph 46. And the reason for this is that case, like this, is one where the claimant achieved what they were looking for, and the question for the judge was causation. And the important point in paragraph 46 is that, and I appreciate that this is looking at the application of the principles that have already been set out, but Lord Justice Mayle says, I see nothing wrong with the approach of proceeding straight to the question of causation in relation to the giving of reasons. And indeed, the issue of causation would only arise on the footing that the appellant had obtained at least much of what she sought. So it is necessarily implicit in the judge's reasons that he accepted the appellant's case on this question. It cannot be a valid ground of complaint that the judge did not set this out expressly. And the point that I will make in relation to this case, of course, is that that's the same here. There was no dispute before the judge. The claimant had obtained what they were seeking. The only dispute was as to whether it was caused by the judicial review or not. And so, in my submission, the fact that the appellant's complaint that the judge didn't consider whether or not the claimant was the successful party isn't a good one in light of paragraph 46 of Parveen.
Well, in the Parveen case, the council saying, well, until you produced a rather late medical report, the position was different. But once we saw the medical report, we agreed to give you the accommodation which you were seeking.
Yes, I mean, quite. One of the points I was going to make in relation to M and Croydon, which is an age assessment case, was that the change of position in M and Croydon was brought about by a new age assessment that had been obtained after the Supreme Court handed down its decision in A in Croydon. That it had been obtained because of the enhanced fact-finding jurisdiction of the administrative court in relation to age assessments, and that was evidence that was obtained and served in the proceedings. And so that's why in A and Croydon there's no consideration of this causation. M and Croydon, there's no consideration of this causation issue because the change of position that meant that the proceedings settled took place by virtue of the proceedings and the evidence that was obtained for their purpose. This is, I can only assume, I'm afraid just off with that I'd have to go back and check the precise facts, that given the conclusion that there was no issue about success and only about causation, that the medical report in Parveen was obtained extraneous to the proceedings.
You've said on half a dozen occasions now that it's never been disputed that the claimants in this case succeeded. But actually that's not what you said to the judge. If I understood the submissions, which appear at 74 of the core bundle, I may have missed something on a swift reading, but I can't envisage that Judge Jarman would have picked up that position from what you then, and your then leader wrote.
If it's helpful, we can turn to them now.
Well,
yes.
yes, I'm sorry to interrupt you, but
No.
where does this?
So if one starts from the defendant's cost submissions, as you said,
Yes.
it says at 74, so it may be helpful to put them in context as to what the claimant has said in its cost submissions.
No. I mean, just for the moment, I mean, the judge has only got basically these cost submissions together with, no doubt, the file.
So,
I mean, looking at paragraph 7, for example, and looking elsewhere to see where the Secretary of State's position was stated to be, we accept that they got what they came for.
So if I could just start at 72, which is in the claimant's submissions, because this is obviously part of the judge's consideration as well.
Yes.
Paragraph 4, claimant submits, this case falls squarely within the first category of case identified in M and Croydon, as the claimant has been wholly successful in obtaining what it sought. Then explains that further. But so that's the claimant's clear submission that is before the judge. We then, if we turn then to 74, the Secretary of State accepts in paragraph 2.1 is that the general rule is that costs follow the event, and that and in 2.2 that where the claimant obtains all the relief that they were seeking, the starting point is that a claimant is entitled to their costs. 2.3, however, importantly, there's the issue of causation. And then if one turns over to para 7, the situation is accordingly that the claimant's challenge failed on ground 3, which it did. It was refused permission. The claimants acknowledged that. And the remainder of the claim has become academic for political reasons rather than reasons connected with the merits. So, and then para 8 deals with the causation issue. So there's no issue taken with the point that was made in the claimant's submissions that they'd been the successful party in terms of obtaining the relief that they wanted to.
Thank you.
That takes me to my fourth point, which is in Parveen as well, so I hope you still have it to hand. I hope this is an acceptable way to do it. What I was going to just take court to was paragraph 23 of Parveen, which cites a previous case on the appellate approach to costs orders, Burgess and Legenvarn.
You're going to tell us what point 4 is first.
Oh, excuse me, sorry. The second point is that the role of an appellate court on appeal in respect of a costs decision is very limited in the way that is set out in the paragraphs that are cited in paragraph 23.
Attenuated, like
attenuated, yeah. Well, it might, yes, well, perhaps. And so I would respectfully endorse Lord Justice Coulson's description from Burgess there. Burgess is in the bundle if you want it, but that seems to me to be a sufficient summary for present purposes, given that Parveen is...
Where is it summarised?
It's page 313,
yeah.
Paragraph 23 of Parveen,
yeah.
And you see the quote is 49 and 50 of Burgess.
Yes.
That doesn't deal with... Sorry.
Would you accept that paragraph 50 refers back to 49? So the first is if there has been an error in law, that means it must be shown the judge has erred in principle in his approach or has left out of account or taken into account some feature that he should or shouldn't have considered. That's what's meant by error of law. It doesn't mean misinterpretation of a statute or something like that.
No, although I can see that the misinterpretation of a rule relating to costs could be a relevant error of law. And I would also accept, just for the avoidance of doubt, that a failure to give adequate reasons would constitute an error of law in this context as well.
I'm sure that's right.
The fifth point, then, is the following. Provided that a proportionate assessment can be made in the way that I described it earlier, a claimant who has been successful in achieving what they sought in their claim, or whom it is, and I'm going to put air quotes around this, tolerably clear would have been successful at the final hearing, is likely to be regarded as the successful party and therefore entitled to their costs. And I make that good. There are effectively two subpoints there. Those who have achieved what they sought are Lord Neuberger's category 1, para 61 of M and Croydon. That's obviously subject to the point I'm going to come on to about causation. And then those whom it is tolerably clear would have won are addressed in paras 51 and 62 of M and Croydon. This might just be a convenient moment to address the submission Miss Apps made, where she says, well, I do say we would have won. That is the first time that the claimant has said, it's tolerably clear that we would have won, and that's a reason which justifies us getting our costs. That isn't a submission that was made to the judge.
I'm getting confused between practical outcomes and legal merits. So which are we talking about here? That there's a possibility, for example, that you've already achieved what you sought and you accepted that that's what's happened here. Subject to causation. And then there's the situation where nothing has been achieved, but there is a hearing coming up, and the court can take a view that you would very likely have succeeded had it actually come to decision.
Yes.
But isn't that concerned with the practical outcomes, rather than with a sort of
in my
legal analysis in a vacuum?
In my submission, it's not, because what the court is doing in both of these instances is assessing who, for the purposes of the CPR, is the successful party in the litigation. And if you haven't achieved what you wanted from the litigation, what the I think it's in M itself, but what effectively the court can do is infer back that you've achieved some measure of success because you've settled on terms that reflect the fact that you obviously would have done, and so there must be something.
So whether you were going to achieve what you wanted at an event that is yet to happen will depend upon a mixture, no doubt, of the legal merits of your case and the and the positionings of the parties, and what the court thinks is likely to have happened in that event.
Yes.
It'll be a mixed question of the strength of your case and the position of the parties.
Certainly at a level of generality, I don't disagree. I think one might have to be quite careful of how it's applied. But that takes me, I think, to my sixth point. I'm hoping I haven't gone awry with my numbering, but I think it's the sixth point. Where it is not tolerably clear who would have been the successful party at trial, a claimant will generally only be considered to be the successful party where they have achieved what they were seeking.
Slow down again. Start point 6 again, please.
Sorry. Where it is not tolerably clear who would have been the successful party at trial, a claimant will generally only be considered the successful party where they have achieved what they were seeking in the litigation because of the legal merits of the claim, or perhaps because of the claim. And so this is essentially the central submission, that there must be a causative link between the success and the claim.
But here we're concerned with a case in which we've got to the point where, but for causation, we have success. So, I mean, there'll be two situations that we've dealt with. One is what we know has happened. Another is what we're projecting might have happened. But we're in the first category here, aren't we?
My submission on the potential merits of the claim is that it's irrelevant because nobody suggested that this was one of those relatively rare cases where the costs judge ought to have found that it was tolerably clear which party would have won. Nobody was saying that. And it's only today that Miss Apps has suggested that her position is that it is tolerably clear. So this whole the whole issue about what role and what test you apply in considering the underlying merits of the claim is, I would submit, an interesting debate for another day, because it doesn't arise in this claim because it wasn't put before the judge. So on the premise that we're not in that category of tolerably clear cases that mean that you can make a cost order one way or the other, it is only where a claimant has achieved what they were setting out to achieve because of the claim. There's effectively those two elements in my submission. Several of the cases, as you've already seen, have been drawn together by Lord Justice Mayles in Parveen. It is, in my submission, clear that the Court of Appeal in that case, I think it was Lord Justice Underhill and Lady Justice Nicola Davies were the other two judges who decided that case. They both agreed with Lord Justice Mayles' judgment. The court, in that case, in my submission, made it clear, abundantly clear, that there was this principle of causation. Just a couple of other cases that aren't cited by the court, or aren't cited as fully as I would rely on them for the propositions which they support. The first was the speciality produce case. You were taken to a couple of paragraphs of that. It is quoted in Parveen, but only one paragraph of it, and it starts at page 119, tab 9. I believe it's got tabs, and I just want to draw attention to the reasoning. The passages which might be helpful for the court to have read really seem to me to begin at paragraph 22, page 131. And the reason I say that's only really an introduction to what follows, is just to make clear that the paragraphs on 132 to the top of 133 are quotes from the judgment below, not this court's consideration.
Mr. Justice Voss, no less. Mr. Justice Voss,
no
less.
I don't intend to accord them any disrespect.
Yeah.
I just think it's important to know what's the decision and what's being appealed.
Yes.
Can I invite the court, please? Maybe not now, but when you're considering just to read paragraphs 24 through to 30 in full. And I would just emphasise, if I may, the end of paragraph 27, the sentence that begins 4 lines up, and then paragraph 30, about halfway down, where it starts, "It is not possible to treat the ministers." That case is another application and an endorsement by this court, in my submission, of the principle that where you achieve your aims in the judicial review by means unconnected with the judicial review, no order as to costs is appropriate. The other two authorities that aren't cited in Parveen are the ZN case and Khan, both the judgments of Lord Justice Singh that you've already looked at. I'm not going to take the court back to them. I should make clear that I don't accept Miss App's characterisation of the case law as 2 different strands of authorities, one about sort of housing cases and one about appeal rights. In my respectful submission, what all of these cases are doing is considering whether the merits or fact of the litigation are what brought about the success. They are doing it in different contexts, but they are simply the application in those different contexts of that more general principle. This was where I was going to make the point that M and Croydon was not a causative link case, and I've already made the point, so I won't repeat myself, but can I just give you the paragraph numbers that show that that was a case where the evidence was, the crucial evidence which led to the change of position was evidence that was obtained for the purposes of the proceedings themselves, and so were therefore intrinsic to the litigation. Those are paragraphs 21 and 22, which you'll find on Authorities Bundle 101, page 101.
The core of your submissions here is that the success that's achieved must be because of the claim,
Yes.
however one says because of the claim. That's maybe not that difficult to assess when one's dealing with an individual application for judicial review. It's much harder, isn't it, to assess that when one is considering what's effectively group action in a sphere that has political significance, because that gives rise to many actors or factors.
I think it's not for me to give evidence, but my experience in this arena is that policy challenges can be settled for all sorts of reasons, and this is a sort of policy, well, it is a policy challenge, or a challenge to the legislation rather than an individual decision. And they can be related to the litigation or not related to the litigation. The submission I'm going to come on to develop as to how you assess it, I mean, I think I agree with the proposition that was, the narrow proposition that was put to me, which is that it's harder to assess in this context.
Well, at some point, maybe you could give us an example of where somebody would be entitled to their costs in a like situation, not necessarily now, but when you want.
Well, I can think of an example where a limit to the funding that was provided to an ex gratia scheme that was that provided funding to disabled people was said to have, for the purposes of enabling them to enter into work, was said to be discriminatory against deaf people, because the limit that was put on what any individual could obtain was likely to disproportionately impact deaf people, because the cost of a sign language interpreter was more than people with other disabilities might require in order to have the same sort of facilitation into work. The Department for Work and Pensions increased in the course of the litigation the level of that cap and I hope I'm remembering this correctly, but accepted that part of the reason was having considered the arguments put in the claim. And up to the point at which the claim settled, if I remember correctly, this a number of years ago now, but let's assume these facts, even if I've got them wrong, then in those circumstances, the claimant was or would be entitled to their costs. The answer to how you go about assessing this is a slightly different point to whether there's this principle of law at all. And the point I'm going to come on to is that when one looks at what Mr. Justice Fordham did in the Wolverhampton case, you have a similar sort of policy issue, and he accepted that a letter from the government legal department in that case was sufficient. And I don't say that that will necessarily always be sufficient, but I do say, in light of the expectation that this court can have of a defendant public authority to act with candour, cards up on the table in judicial review, that a qualified solicitor from the government legal department saying explaining the basis of the decision in accordance with the duty of candour, and one assumes in accordance with the instructions that they have from their client, is capable of discharging this burden. And one of the reasons I drew the court's attention to the proportionality issue is because, of course, this assessment has to be made in a proportionate manner, and when I get to it, I'll draw the court's attention to the relevant paragraph of Parveen that says that evidence in the form of witness evidence is inappropriate for this sort of an assessment. That's not, of course, to say that it would be necessarily wrong to explain it in that way, if that's appropriate in that case, but I would accept that, at least as a generality, evidence is, in terms of hard documentary evidence or a witness statement, is, given the need for proportionality in this sort of context, unnecessary and inappropriate is the language of Lord Justice Males. And so, while it might be right that it is harder to assess in the context of a change of policy position, this is something which the Administrative Court deals with on a very regular basis. Mr. Justice Fordham has, just as by way of an example, in the Wolverhampton case, accepted a letter from the government legal department that says that the cause of the change of position was different to, it wasn't caused by the litigation, and ordered no orders to costs on that basis. And of course, the starting point that if the process is disproportionate, you order no orders to costs, means that if it's a hard process to undertake in the circumstances, that you also end up in the same place. That ultimately, if the court isn't satisfied as to what the reason for the change of position is, it obviously can draw inferences from the timing of the settlement or whatever, but if the court is not satisfied on a summary basis, then the appropriate order is no orders to costs. My seventh point, there is no principle that acceptance by a defendant that the decision challenged was flawed gives rise to a separate basis for awarding a claimant its costs. This is what I hope I don't too pejoratively describe as the claimant's gotcha point. The point that you said that you thought it was unlawful, and therefore we're entitled to our costs. Now, of course, if a defendant accepts that a claim is meritorious, and that is the reason for the settlement, there will be a requisite causative link. But the principle is there a causative link? And the defendant's acceptance of that will obviously be deeply evidentially relevant to that question, but there is no separate principle that the defendant's acceptance gives rise to a right to costs. I'm just conscious of the time, so if I can just give the references. I mean, I'm happy to.
It's all very well to say give the references, and then tomorrow or next week or next month,
let me take the
we think, what did he mean by that? So can you just take
No, of course. So the relevant authority here is TESFE. That's at Authorities Bundle, tab 11. It begins at page 146. The relevant passages were, well, this is the claimant's authority. This is what the claimant relies on in support of the proposition that there is some other authority that sort of got that if you can show that the defendant has accepted there was illegality, that they're entitled to their costs. The relevant passage starts at 63, and what one sees at 63 is a submission that was there made by Mr. Payne on behalf of the Secretary of State, that the withdrawal of the decisions does not amount to an acceptance that they were materially flawed. And Lord Justice Lloyd-Jones said, I'm unable to accept that submission. And what the claimant reads from that, as I understand it, is that Lord Justice Lloyd-Jones is rejecting is effectively endorsing that if there had been acceptance, there would be an entitlement to costs. And my submission on this, and it really goes down to the end of paragraph 68 on page 1673, my submission is that when one reads Lord Justice Lloyd-Jones's consideration of that submission, what he does is finds that the reason for the decision was the litigation, or was the legally flawed nature of the decision, which led to the litigation. In 64, he says, the decision to withdraw was essentially because of the flawed legal approach. He notes that other claimants raising the same grounds had succeeded in getting permission, had been successful in their claims at 66. And so it isn't any sort of analysis as to whether the Home Office has accepted the breach. What he's doing is just saying, well, what was the reason? And he finds that the reason was the legal merits of the claims.
As disclosed by decisions in
the Supreme
other
Court.
cases,
Yes.
First in this court and now in the Supreme Court.
Yes.
Yes.
So the submission that the claimant made, at least in writing, was that effectively the fact that a defendant accepts the position means that they're deemed to be the successful party. And that's the paragraph 63, and I think the first sentence of paragraph 63 is what the claimant relies on for that. And the point I'm making is simply a responsive one, which is that when you read the rest of the analysis, it's clear that that isn't the proposition that Lord Justice Lloyd-Jones was deciding. Proposition 8, we're almost there. In determining whether there is a causative link, I accept that it is for a defendant to explain what the cause was, and I accept that the explanation can be properly scrutinised. That is paragraph 63 of BACTA. That's clear. No one is saying, hoist the flag, GLD can say no causative link, and the court simply has to salute that flag. That's nobody's submission. It doesn't follow, at this point 9, in my submission, that evidence is required to demonstrate that the cause was other than the proceedings. And it's right to note that BACTA at 63 doesn't say that. It just says that in that case, no evidence was provided. Indeed, evidence, at least in a formal sense, will usually be inappropriate. That's Lord Justice Mayall's words in Parveen, paragraph 40. And in my submission, this follows from the need for proportionality and the fact that the court can expect a defendant quite properly to comply with its duty of candour and to properly and to explain why it came to a decision it did. There's a decision of the upper tribunal at the very back of the bundle, decision of Mr. Justice Swift and upper tribunal Judge Smith, and there they conclude in relation to this that a tribunal at the beginning of the judgment they consider that the tribunal's costs principles in the judicial review are the same as the administrative courts, and they then say, this is paragraph 26, page 450. When deciding whether a causal link does exist in any particular case, a tribunal ought to take into account such information as is relevant as it is available to it at the time the decision falls to be made. And I appreciate that's a pretty generalised statement, and perhaps doesn't take the court very far. But
the important word is information.
Precisely.
Yeah,
precisely.
I mean, in other words, it doesn't have to be.
We're not talking about affidavits.
Yes, but I mean, just in this case, by contrast with Wolverhampton, what has the Secretary of State offered by way of explanation of the either relevance, irrelevance, or something in between of the action against the government?
The Secretary of State explained in the correspondence from the Government Legal Department that the decision was taken in accordance with the pre-election commitment, and not because of the proceedings. It's quite difficult to. It's in relation to Wolverhampton, which I'm going to come to.
Yes, I know. But would you like to plant your flag, as it were?
Of course.
Where you think it best sits, in relation to the assertion that was made as to what the relative significance was of the proceedings with regard to the decision.
So the proceedings is in the costs bundle, which is at tab 3 of the supplementary bundle before this court. And apologies. So we start at, I appreciate the court's already been taken to, I think, quite a lot of this, but so we start at page 60 in the supplementary bundle. It's a letter from the Claimant solicitors. Just to note the chronology, the general election was on the 4th of July. The Prime Minister was appointed by the King on the 5th of July, and that was a Friday. This is then, I think, the following Tuesday, 9th of July. And so this letter is sent, I think it's fair to say, while the government is in the process of being set up.
Yes.
And so this is a letter, we're aware, you've been taken to the paragraphs that say, we are aware the incoming Labour government has made clear its intention to repeal minimum service legislation in its entirety and will include the regulations. We are therefore writing to ask you to take immediate instructions as to whether it intends to continue to defend the proceedings. And then, etc., etc. There's then a period of just under a month where inevitably new Home Office ministers need to be briefed on a whole range of things. But I don't think it said that that's an unreasonable period of time to take for responding. And there are, I think if I can just deal with the two letters, the 6th of August letter from the Minister and the 7th of August letter from the GLD separately. In relation to the 6th of August letter, it starts at page 58, the point that I perhaps intemperately made whilst Miss Apps on her feet, that this was one of several letters that went to all of the Home Office trade unions, is made good in the very final line at the top of page 59. And this, of course, isn't a letter that is sent in this litigation. Well, it's copied to the solicitors the day after in the litigation, but this is a letter that is sent outside of the litigation process to the President and Group Secretary of PCS in normal industrial relations channels that the Home Office has with their recognised unions. So I'm writing to update you on the government's plans for the strikes, Minimum Service Levels Act, begin by paying tribute to skilled professionals, etc. 2023 Act, the next paragraph, 2023 Act enables minimum service levels to be applied. The government believes that that Act unduly restricts the right to strike and undermines good industrial relations. Of course, undermining good industrial relations has nothing to do with Article 11 ECHR. And then, as you are aware, our plan to make work pay, i.e. our pre-election commitment document in relation to work and employment law, pledged to repeal the 2023 Act to give trade unions the freedom to organise, represent and negotiate on behalf of their workers. We've begun preparations to repeal the Act as part of the employment rights.
You don't have to read the whole thing. If you're saying it doesn't refer to the ECHR anywhere or Article 11 anywhere, yes.
Quite. It refers to features which are all of themselves political. They may also be expressed as legal propositions, but they are all political points. And that, I mean, when one reads the whole thing, the importance of negotiation, discussion, etc., this is a letter that reads as a letter to trade unions as part of labour relations. The only reason that then gets caught up in this costs issue is because it's then sent under cover of the letter from GLD the next day to the solicitors who act on behalf of the claimants. And specific points are drawn out in the second paragraph. And then in the final paragraph of page 60 notes that the claim has not demonstrated that the claim has become academic. Putting aside burdens of proof, the position that's taken is it hasn't become academic by virtue of the legal merits of the claim. It's become academic for the reasons set out in the enclosed letter. And I think it's fair to say that the assumption underlying that is that the reasons given in the enclosed letter are to be contrasted with the legal merits of the claim. And so when my learned friend says, well, but the 6th of August letter says unduly restricts and that must be an acceptance of the legal merits of the claim, GLD, with respect, are saying that it's clear from that paragraph, or tolerably clear from that paragraph, that they're saying it's not become academic by virtue of the legal merits of the claim, it's become academic by virtue of other reasons. We then, at 62, get the response of the 9th of August, and really the point that's made there in the bottom paragraph is that it's not tenable to argue that a claimant is not entitled to costs where a defendant grants the relief sought but contends it was for reasons other than the legal claim against it. No authority cited, and of course that's wrong on the authorities. It would otherwise be open to a defendant to avoid costs liability simply by stating that they're granting the relief sought for other reasons. And for the reasons I've said, that's not right. We can't just hoist a flag and state boldly and not expect it to be scrutinised pragmatic reasons or other reasons, as was the case in Baxter. And of course, this isn't a case where there's no other background information for Thompson's or the judge to go on. They know that there's been a pre-election commitment. They've referred to it in the correspondence that I took the court to. They know that the expectation is that the government is going to repeal the legislation, and they've said, well, that's why this case should end. And so it isn't simply a bald assertion in a vacuum. This is central context to the decision which the judge had to make. And of course, if that were in doubt, at 64, about halfway through the paragraph, we say, or GLD says, following an election, the fact that following an election a new government has chosen to pursue a different policy choice within a wide margin, the wide margin accorded to democratic administrations of the Council of Europe member states, does not even arguably advance your client's case to the recovery of costs of pursuing submissions which have not to date been adjudicated upon. And the point is effectively reiterated that this is just a different policy choice within those that are open to...
I think what I was curious to see is whether you were going to take us to somewhere where it said, really, your action made no difference at all. We probably aware of it, but frankly, what about that?
I think
that assertion has so far not been made.
I think that's right. Let me just... with respect, I suspect that it may have been thought so obvious that this would have happened in any event, because we'd promised that it would happen, or the government...
It's too obvious. I mean, you're speculating, I appreciate it, and I'm not criticising you for doing so, but you're speculating that it might have been too obvious to merit saying, or maybe it would have been considered impolite.
Well, I mean, well, factually, I think it's right that at least in the correspondence, I was just going to have a quick look in the cost submissions, but it's right that in the correspondence, it wasn't said this had nothing to do with your claim.
No.
But equally, it seemed, in my respectful submission, it's tolerably clear that that is the implication of what's being said.
But it found to be the case that having done something similar in Wolverhampton, just simply saying, well, I'm sorry, but actually this didn't affect us at all. The court accepting that. It would, in a sense, easily have been open to the minister to have done that in this case, if that had been the case. Just nothing to do with that decision.
Well, the correspondence says what it says.
Yes.
In my submission, if it's not expressed, the clear implication of the correspondence is it's not to do with the judicial review. And we say expressly in that correspondence what it is to do with, which is the political situation changing.
Well, I suppose you point to the 7th of August GLD letter. It does make the point. Your client has not demonstrated the claim has become academic by virtue of the legal merits of the case. The claim has become academic for the reasons which are set out in the enclosed letter. Yeah. It doesn't quite say the claim has had no effect on them.
No, I mean, perhaps it could be more clearly expressed. But
it was you've given us point 8, which is it's for you to explain what the cause was.
Yeah. Well, and in my submission, the cause has been explained. It has been explained that there is a change of policy which was pursuant to a democratic process in terms of drafting the pre-election material, and then within the Labour Party, and then a democratic process of electing them. And then, if there was any doubt at just in our cost submissions that were put in before the judge, at paragraph 7.2, this is core bundle 75, having said that the claimant's challenge failed as it did on ground 3, 7.2 then makes the point that the remainder of the claim has become academic for political reasons rather than for reasons connected with the merits of the claim.
I'm sorry, what was the page you were reading?
Sorry, it's 75 in the core.
75, thank you. So, is this
core.
Core. Thank you.
Left back to the core.
Yes,
So it was just 7.2.
Oh, good. Thank you.
So so my ninth point was that it doesn't follow from the need for an explanation that there needs to be evidence, and I think I've made that good by reference to Parveen and the IX case, which was the one at the back of the bundle. The 10th point of my 11 points is that letters from solicitors and or submissions from counsel may suffice.
Wait, what was 9?
9 was that it doesn't follow from the fact that an explanation is required as to the cause, that evidence is required.
I've just completed my note about 7.2. It sets up a dichotomy between political reasons and reasons relating to the merits of the claim. Why are those in?
Because those are the only two reasons that were being suggested.
Yes, but you can have something that's both. In this case, what's happened here is both. The government has accepted something because it thinks it's right.
No, the government's accepted something because it thinks, as a matter of principle, it's right. It's not accepted that
the legal challenge.
You have to include the word legal, do you, in 7.2 to understand correctly what's being said there.
Well, because the claim is to vindicate a legal case, not to vindicate a political case.
Right. I mean, this may have been the claimant's attempt legally to get what they sought politically. In the event, they didn't need to do that because they obtained, by the Labour Party winning the general election with their support, the result that they wanted politically.
Okay, you were saying point 10.
So point 10, letters in terms of what is sufficient. Letters from solicitors and or submissions from counsel may suffice for the purpose of explaining why the decision was taken to settle a claim. You've already been taken to Wolverhampton, paragraph 8, Roman 7, at page 344 of the authorities bundle. I don't say, just for the avoidance of doubt, that that's the only way that one can explain it, but it's certainly, but I would endorse Mr. Justice Fordham's approach in that case as an appropriate approach. And then, whereas here, a claimant effectively seeks to go behind what has been said to the court as to the reasons, as to the explanation provided, in my submission, the usual approach on judicial review applies in relation to the approach to evidence. If there's something concrete that shows that actually it was cause X instead of cause Y, a document, for example, then so be it. But I mean, I've set out the principles on what we said about how the burden works in paragraphs 28 and 29 of the skeleton. In the absence of any contention that the explanation is wrong, it's difficult to see how the court could do anything other than accept it, particularly in light of the fact that, and that's not to say that it shouldn't scrutinise it, but in light of the duty of candour, provided an explanation, proper explanation is given, and my submission is, as I've already said, that one was given here, then the court will accept what the defendant says in the normal way. Defendants can be trusted to be candid, at least as the starting point. So that was my 11th point, just as to where a claimant seeks to go behind an explanation. The usual rules as to the assessment of explanations provided by a public authority in judicial review apply. I mean, the paragraphs 28 and 29 of the skeleton do it by reference to the assessment of evidence in judicial review. I'm not sure that there's any difference in principle between how a court would approach an explanation versus how it would approach the witness statement, for example, of a civil servant, but at least not in any way that makes any material difference to this case. So those are my 11 propositions. We've gone through quite a lot of the facts as part of our exchanges already. I don't want to duplicate what we've already done. Can I just pick up a couple of points that were made. One I've dealt with already about delay. The other was just about the pre-action protocol process, and the points about disclosure not being provided with the pre-action protocol response. If the court just turns up the claimant's submissions to the judge, which are at the relevant paragraphs, paragraph 73, Ms. Apps rightly said that the procedural matters like this were dealt with in the submissions, and they were, and she said that they were dealt with as the fifth point, and it's right to note that the extent to which they were dealt with is the 3 lines at the very bottom of the submissions on page 73.
Sorry.
Call bundle 73.
And paragraph 2 as well.
Right, so thank you. So, quite right. Some paragraph 2, last penultimate sentence, excuse me, says some disclosure of ministerial submissions, but not all of the documents sought was made on detailed grounds. Detailed grounds were filed on the.
So sorry, Mr. Skinner. Call bundle 73.
So this is now 72. Sorry, paragraph 2, 72.
Yes.
So the claimants asked me to draw your attention to, I think, the penultimate sentence of paragraph 2, that some disclosure of ministerial submissions were made, but not all of the documents sought, with the detailed grounds. And then my point was, if one looks at the end of page 73, subparagraph E, fifthly, this is the extent of the complaint that is made about procedural matters. No mention of pre-action, non-disclosure. This is just responding to the point Ms. Apps made about the pre-action process and non-provision of ministerial submissions with the response to the pre-action letter. And so I would ask, we've obviously, the court's obviously looked at the claimant's submissions on costs, the defendant's response and the claimant's reply. That and the bundle, in the costs bundle, tab 3 of the supplementary bundle, is obviously the material before the judge. That is appropriately limited, appropriate in form. Notably, nobody suggested until the claimant's reply that evidence was required, and in any event, for the reasons I've given, it's not. And so when one then turns to the decision of the judge, which is at core bundle page 49, tab 4.
You suggested that evidence in the sense of witness statements was required.
Sorry, my lord, I didn't quite catch
Nobody suggested that evidence in the formal sense, witness statements, was required. But the judge was given the costs bundle with submissions and asked to make a decision on the basis of submissions plus documents.
No, well, I would just point to page 77, which is the claimant's reply. In paragraph 3, excuse me, their second point in reply, they take the point that the defendant has neither sought to submit evidence in support of their cost submissions in the consent order, nor along with their submissions. So the point was taken in reply, but not before we'd had the opportunity, not before we put in what we wanted to, that the evidence was required. Okay, well, I'm told that in the correspondence, the relevant paragraphs of authorities that suggest that evidence might be required, despite the fact that the Court of Appeal said it's not, were referred to. I'm afraid that point was not picked up by me when I drafted our defence submissions. But the first time it's expressly dealt with in relation to the need for evidence is paragraph 3, the second point on page 77. But I mean, the key point is, as I've already submitted, that evidence isn't required. As Lord Justice Mail said in Parveen, it's inappropriate in at least the generality of cases. That caveat is mine, instantly, not Lord Justice Mail's. So, sorry, I was going to go to the decision that's under challenge. Tab 4 of the core bundle, page 49. I mean, for the first point in the reasons, well, the first point is that this isn't a case where there is no reason, where there are no reasons given, unlike English and Emery. There were reasons given, and they are, in my submission, appropriately concise for the sort of proportionate summary decision that a judge of the administrative court is making when presented with a bundle of papers in relation to costs. The first paragraph that states the conclusion, the appropriate conclusion on the basis of the submissions, is that the claim became academic for political reasons after a change of government and not because of this claim. So the judge's conclusion is effectively to accept what we say the defendant clearly said in correspondence and in our submissions. Now, we've had a back and forth about whether we did clearly say that, but that's clearly the judge's reading of what we submitted correctly in my submission, and that was a reading that he was entitled to give to the submissions and the evidence that was before him, and a conclusion that he was entitled to reach as to the reason for the claimant's success. The judge then notes in paragraph 2 that the other points made in the submissions are noted but do not impact upon that conclusion. So he's saying, I've read the submissions, I've read all of the other points that you've made about the claimant being the successful party, the conduct or otherwise, and they don't move the needle. The basis for my decision, it still stands. And so it's not right, as the appellant alleges, that the judge simply hasn't taken into account any of the other material. He plainly has. I think the phrase may have been used, he didn't engage with it, but there's no duty to engage with in the sense of expressly wrestle with each of the points in turn. He's expressed his conclusion in relation to them, which is appropriate conclusion is that it was a political decision, not one resulting from the legal merits. The other points, I take them into account, but they don't affect my decision. That too is in the discretionary decision about costs, a conclusion that the judge was plainly entitled to reach. And then thirdly, in those circumstances, the above cost order is just and proportionate. And in my respectful submission, that cannot be properly criticised. And certainly when one, and that's of course not to say that any of your lordships or ladyship would have reached the same decision, because it is a discretionary decision, and but it is the decision that the judge reached having considered the materials and the information that was put before him. The legal basis for the decision, that there is a requirement for causation between the proceedings and the success, is well established. He was taken to, his attention was drawn to certain of the authorities. Obviously not, of course, in any of these cases, there's a danger that this is I don't want to speculate how long a judge would take, but say half an hour consideration of the papers versus a day in the Court of Appeal. Of course, we've looked at more authorities, gone into more depth than would be open to the judge, but that's not a basis for criticising the decision.
Seems to be approaching matters on the assumption that there's one reason why people do things. And whereas in real life, people do things for many reasons. Are you submitting that the test is that in order to get your cost, you have to show that you're the reason?
No.
How would you put it?
So the way it's put in Parveen, I think, is a helpful way. Lord Justice Mayles, said, if I remember rightly, says it's I think highly relevant and often decisive factor that whether or not the claim was unrelated to the outcome achieved. But
I mean, if the test is that it was, you don't get your costs if it's unrelated, understand that. Nobody would complain about that. But there is there is open ground between unrelated and the reason.
Of course.
I'm trying to identify where we get some help about the fact that, let's suppose that one was looking inside the mind of the minister and was thinking, well, there are 4 or 5 reasons why I would want to do this. It was in our manifesto, etc. And one might hypothesize that amongst those however many reasons, one of them is because the unions have sued the government, and I need to deal with that litigation as part of my brief. Now, where do we find in the authorities, or indeed in this case, what seems to me like a very real possibility that people are motivated by a number of reasons?
So certainly Miss Apps has drawn the court's attention to authorities that suggest that it must be the settlement of the claim must be entirely extraneous, I think was the way that Lord Justice Laing put it, or entirely unconnected to the claim.
Yes.
And that I think for the purposes of this challenge, I'm content to proceed on the assumption that that's correct, because that was the basis, that was the legal basis on which...
How could the judge in that case, that seems to me, if I may say so, to be a very sensible approach, but how on that basis could the judge find that the major action that had been taken by a union, a large union, was extrinsic or not related? What was the basis upon which he could so find?
Well, firstly, on the basis of the evidence and the submissions that was...
Right, so deductions from the correspondence.
Yeah. And if he can't,
yes,
then the answer is no orders to costs, because you can't determine the question. And so you
but,
end
but
up
yes,
in the
but
same
if the burden's on you to show...
Well, the burden's on us to explain, and then in the normal way in judicial review, the defendant...
Yes, but I can understand that you can explain it wasn't the reason why we did this. We had reasons of principle for doing this. It wasn't the reason, but you've never said it wasn't a reason.
Well, no, but partly that's because we said what the reason was, which was the carrying into effect of the political promises that the Labour government, the Labour Party had made to the country in the run-up to the general election.
Well, the conclusion, if one accepted that submission, is that the major piece of litigation was completely irrelevant.
It was completely irrelevant.
Completely irrelevant.
It was. That's the position that we adopted below. That's the position I adopt. Those are my instructions. They haven't changed. It was completely irrelevant. Had it had no impact on anything.
Yes, but that's because there was a change of government. So what's the position before the change of government?
Well, before the change of government, the Secretary of State was defending the judicial review on the basis that we were going to win it.
I think we got a bit stuck.
Yes, I'm sorry. It's my fault.
Well, let me just double check that I've covered everything that I need to cover, but I think we may be happily approaching the finish line, at least of my submissions. So what I was just going to say is that the wholly extraneous, totally unconnected, however one quite wants to put this, was the basis that the claimants said was the proper approach before the judge, and there was no disagreement with that. What we said at 74 was that there had to be a causal link, and that is how some of the cases put it. So in terms of the judge's assessment, the assumption that or inference that the court should draw from the judge's reasoning is that that is the approach that he took. Just picking up some sundry points from my skeleton that I haven't dealt with, but
Yes,
just very briefly.
That's fine,
Just
Mr.
for
Skinner. If you want to
completeness, really,
pause for a moment and read it back to yourself.
Just to highlight that the submission was made, at least in writing, by the claimants that to the extent that the judge suggested that there was some principle that a defendant will avoid costs liability in circumstances where a judicial review becomes academic for political reasons, this is wrong. I accept that. That's not the law. The law is about causation, not about what the extraneous factor is. And the judge didn't suggest that it was a sort of political reasons test. It just happened to be in this case that it was political reasons that led to the change of position.
Well, that was your argument, but the judge's very close to one line answer is claimant gets no cost because the defence was withdrawn for political reasons.
And he says not because of the claim.
Yes.
So it isn't. It is drawing a distinction between the different causes rather than.
Yes, so he might have said other reasons.
There are different ways that he could have expressed himself, but given that the reason for the decision was political, there were no other reasons put forward. That was the reason for the decision. That was what was said. He was entitled to draw the distinction between doing it by reason of the claim or doing it for political reasons. I should just deal, finally, if I may, with the point that's made about chilling effect by the claimant, about claimants not being able to recover their costs having a chilling effect. I think that there are 2 points, really. I make them at 37b, Romans 1 and 2, but just to highlight them.
Of your skeleton?
Of my skeleton, yeah, which is at bundle 46, that's the relevant page. There are really 2 points here. One is, we're only talking here about cases where it isn't tolerably clear who would have won at trial. So it's if you are a obviously meritorious claimant, then you'll be entitled to your costs in any event. There's no chilling effect by the causation requirement because you can show the judge that it's tolerably clear that you would have won, and therefore you'll get your costs regardless of the reasons for the decision.
So essentially, for the 2 reasons you give,
Yes.
If it has a chill on poor claims, that's not a bad thing.
Well, I don't need to go that far, but I mean that's probably right as a matter of general principle. But certainly it isn't going to have a chilling effect on a certain category of good claims. And the second point really is then that in relation to the others, the principles applicable are clear in my submission, and that there does have to be this causative link when one looks at the cases. That's well established, and the courts have established that it isn't just to make a costs order in a claimant's favour where there is no causative link, and in those circumstances, the claimant's complaint about chilling effect is a complaint about the state of the law, not about the decision in this case, and that's. Obviously, that presupposes that you accept my submission that the cases establish what I say they do. But that being the premise of this submission, that's just the way. That's the proper application of the principles and the way justice is done in these cases. If I could just turn my back to make sure there's nothing else of those instructions. Those are my submissions.
Thank you very much, Mr. Skinner.
My lords and my lady, taking care not to drop my laptop, I'm afraid. In general, I'm going to plan to follow the same order of the 11 propositions, which I hope will be helpful in terms of following the notes of Mr. Skinner's arguments. But if I can just pick up at the start 2 points. And one is about the significance of this word political decisions. I obviously act for a trade union in this case. To some degree, when trade unions bring judicial review proceedings, they might do so to support a member, but because this is a costs shifting regime, generally speaking, trade unions and charities will do so where there is a broader benefit to other people as well. That it's not just about the one, but it is political in that sense that it has a potential impact on others. There are plenty of decisions that can be made unlawfully, for instance, in breach of a duty of consultation, in breach of the PSED, failing to follow a particular procedure set down in statute. But there might also be political reasons to do, or there might be other political reasons to do something else. So what is significant in this case is both the brevity of the judge's reasons and also the way in which this decision has then been used in other cases where concessions have been given and U-turns as a reason why the claimants who have launched judicial review proceedings, and the point has now become academic, should not get their costs. So this is a point of broader principle because of what can hide beneath that word political. And if accepted, it is our submission that it would mark a very significant departure from the way in which the Court of Appeal has approached costs in judicial review proceedings from barter. So taking the list of propositions from the top, Proposition 1 was costs are always fact sensitive. CPR 44.2 is a discretionary power, but it is a discretionary power with principles that are well established both within it. Costs follow the event. What's the event? Relief. And because of the detailed argument made in Barter, departing from Boxall, and followed in and Croydon. So yes, we accept it's a discretionary judgment, but we say what has gone wrong here is an error of principle in terms of the starting point. And there are costs appeals that do succeed. Principle number 2, decisions on costs following settlement will only be made if proportionate to do so. And I think it was my Lord Justice Jackson and my Lady Justice Laing asked, oh, what does that really mean? PCS said we had to be very careful about that principle. And the high point is at paragraph 29 of my defendant's skeleton argument, where he says, where a claimant begs the indulgence of the court to decide it. Now, this was an area that the Court of Appeal was very alive to in Barter. A claimant who succeeds in getting the relief is entitled, the starting point is they're entitled to their costs. The guidance from the administrative court is that the defendant needs to go first to explain why not. A claimant shouldn't be shut out from accessing the court, particularly in a procedure like judicial review that is so front-loaded. We can test this against the time point. At the time of the bringing of proceedings in March, there was a Tory government. There was going to be an election at some point. Could PCS put all their eggs in the basket and wait and see what happened politically? No, in particular because they actually had strike action ongoing. So it made a real practical difference to be able to come to court and say, look, Regulation 3, there is a problem here. It's an Article 11 problem. This is overbroad. It's 100% MSL. That there was nothing inappropriate, and it's not rightly not said by Mr. Skinner that it was inappropriate for proceedings to be broad. And this is, and the court granted permission. Principle number 3, that the duty to give reasons is attenuated, and reliance was placed on English, Emery, and Reinbold. I hadn't appreciated from Mr. Skinner's skeleton that he was still running English and Emery Rhyme Rolls. He relied on it in resisting permission to appeal. English is obviously a case, the key point decided in English was where a first instance judge who's heard a hearing is appealed on the basis they fail to give reasons. What process should be followed? Should there be a process of going back to the judge for amplification of reasons? Now that's not even open to us in a situation where a judge decides costs on the papers because of CPR 52.3. We have to go straight to the Court of Appeal. We can't go to the judge below. The English Emery and Rhyme Rolls principle isn't even available to us as a way to get more reasons out of HHJ Jarman in the context of this particular procedure. We also say that it's factually the particular case in English is different because it was a decision after trial. And if we look, I'll only take you very, very briefly to back to paragraph 110 and 113, which I think is on page 42 of the authority bundle. This is not a sort of Edmund Croydon got all of the relief sought. The judge found that it was a draw. You get the word draw in paragraph 110. And what happened was that the claimant initially claimed that there were 65 items, then claimed there were 40 items, and the number of items decreased, and there were offers backwards and forwards. Now, I'm obviously not on this appeal going to disclose what Calder Bank offers be made. That's not relevant, and that's not something should be decided here. But the position of government was very clear. They weren't going to pay any of our costs. This wasn't a bargaining backwards and forwards. They said, your costs are unacceptable. If anything, you should be paying ours. What it doesn't establish as a matter of law is that a 3-sentence decision that's been made on this process by a judge sitting on the papers is entitled to give no reasons at all. And we've seen in the bundle, I took you to Parveen, how much detail there. You've seen Wolverhampton, how much detail there. Very strikingly different from the 3 sentences here. And I'm going to take you to City Portfolio shortly as well, which is another decision, substantially longer. Mr. Skinner also relied on Parveen. I'm not going to take you back to it, but the paragraph in Parveen, we saw it at the time, paragraph 22. That's not all of the reasons, that's part of the reasons after the recitation of what the case was about. And what we have here that's different factually to Parveen is we have that letter from the minister that uses that terminology, unduly restricts, which Mr. Skinner says has nothing to do, only about politics, nothing to do with the issues in the case at all. And we say, well, it's very similar to the issue here, in the same language, the language of proportionality. Now, I appreciate that before lunch you indicated that you were not minded to look at all at Hansard on the basis that it's not from the sponsoring minister. I have a reference for you if it's helpful, and I discussed it with Mr. Skinner.
I don't think it is, Ms. Harris. We went over this morning. We ruled for good or ill. We're not prepared to look at Hansard.
There is a principle that if it records something uncontroversial, that it is legitimate for a court to look at it. And I hadn't understood Mr. Skinner to say that Lord Coker's position had not been said, and that wasn't the position of the Labour Party. We also see that, not in Hansard, in our letter on page 71 of the bundle, we said the Labour Party's position on Reg 3, specifically, wasn't just that it was a bad idea, but it went further and was into unlawfulness territory. And that establishes a degree of linkage. We also say, it's page 71 of the supplemental bundle, we refer to the case of City Portfolio at 17. If I could just ask you to turn that up, it's behind tab 23 of the authorities, on page 397.
Yes.
And this is a decision of Mr. Justice Fordham. We've already read Mr. Justice Fordham in Wolverhampton,
yes,
going through that detailed exercise of considering the ministerial submissions, which, as I said, has until this case been common practice, where there's a U-turn and it's said to be for a reason that's in the world of politics. 17, page 379, is Mr. Justice Fordham making the evidence point really, really clearly. This is So we were somewhat surprised not to receive anything.
What page?
397 at the bottom.
Thank you.
The facts of this case are somewhat complicated because they live in the world of planning. I can summarise them if it's helpful. The city portfolio owned a parcel of land near a piece of land which had on it a hospital that was then covered by a conservation order. City portfolio brought a challenge. By the time of the challenge, there had been another decision and another order made, which it changed the complexion of things. But what Mr. Justice says, Fordham says at 17, is that the defendant in that case is the further process of consideration. So that's the new consideration of the whatever the planning term is, the conservation area, had nothing to do with the claim. Defendant's written submissions have made further points.
Sorry, Miss Apps, it may be my tired little brain, but I really can't take this in orally in reply. Just tell us what this case decided
It says
in relation to costs.
It says you need evidence. It's not enough just to say it in a letter. It's not enough just to say it in submissions.
Yes.
It also addresses who has the burden and places it at the door of the defendant if they want to say that the reason was something else with the sufficiently different to the challenge. So the point about us only raising the evidence point in reply is not factually correct because it was raised in the letter by reference to paragraph 17 of City Portfolio. There wasn't a kind of ambush gotcha point. And it was put by reference to our understanding, PCS's understanding, that Labour's position on Reg 3 went actually beyond just it's not a good idea.
Right.
Principle number 4 is about the role of the appellate court is limited, and Mr. Skinner relied on Burgess in the case of Burgess. Now that is a case where the appeal was actually allowed. Burgess doesn't say you can't allow a costs appeal. It says that you need error of law or perversity, but it was actually a case where the judge had taken the wrong starting point. So we said that doesn't help Mr. Skinner to refer to Burgess. The judicial review costs authorities are full of references to the standard of appeal. Our own skeleton refers to Tess Fay, paragraph 13. It's also in M, very similar paragraph. I'm not saying it's higher than that, but I'm saying it's not impossible. And one needs to look at what approach the judge took. Did they start from the Barter and M position? Or did they too quickly fall back on no order for costs because they said it was because they thought it was difficult or they thought it was political? Principle 5, Mr. Skinner essentially elided category 1 in M in Croydon, where a claimant gets all of the relief, with M and Croydon 2, which is where the claimant doesn't get all of their relief, but it's tolerably clear that they would have won. And there's a M and Croydon sets them out as 2 different categories of case. Not as a statute, all cases will ultimately depend on their facts, but there is no need in this case, and in fact it would be wrong in principle, to throw away the way in which costs are looked at in M and Croydon, which is an approach that's been followed for the last 13 years, or longer if you counted it coming from Barter. And in my submission, Mr. Skinner can actually only win if you actually allied the 2. And essentially what you do is you take the approach back to Boxall approach. Because the 6th principle from Mr. Skinner was where it's not clear who would have succeeded, the claimant will generally only be considered successful if they got what they were looking for because of the legal merits of the claim or because of the issuing of the claim itself. And we say that that's actually not what M and Croydon says. It's not what CPR 44.2 says. And we can test it. What's the connection with the litigation in this case? And the connection with the litigation in this case is that we wrote on the 9th of July and said, are you still defending the claim in line with your detailed grounds? Now, Mr. Skinner said something very interesting. He said, well, actually, if GLD had replied to that letter, and we set a a long deadline. We set 24th of July as the deadline for that letter. GLD had replied and said, oh, we're taking instructions from the minister. And then they'd sent the ministerial letter. They might have to pay our costs. Well, what they did do was that they didn't reply to it at all by the 24th of July. And we do make some criticism of that. We said we do say, we send you a letter saying, are you defending? We would expect to have some kind of reply, even if it's saying, we will take instructions, our ministers are terribly busy. But what we then get is the letters landing on our desk simultaneously, a letter from GLD saying, thank you for your letter of the 9th of July, at the same time as the minister says, oh, and we promise never to use the power in these regulations at all. And we do say that in the circumstances of that chronology, that is sufficient linkage with the litigation. And it's sufficient linkage because we were the party with the next jobs to do, essentially. We had to pull together our reply evidence. And then we had a hearing in November. So absent us taking steps to discontinue the claim, that hearing's still in the diary. And we were asking the defendant, are you actually relying on what you've just filed so that we need to read it and do some work on it? Or are you actually going to give us what we asked for originally, which is a promise not to use this power at all, which they did. And the only issue became costs. So we say on these very narrow facts that there is that linkage with the litigation. Now, as the Skinner says, no, we took the decision for political reasons because in May, May, after the election had been called, the Labour Party published a manifesto saying we're going to repeal the Act. So that's very interesting that you did that in May. In fact, that's consistent with the political position of the Labour Party that predated that. But we have a narrower issue here, and we really, really need to know. We need to know because we've got live industrial action on. So, are you going to use this power, or are we actually under this regulation, not knowing whether it's going to be used or not?
So you're going back and emphasising the fact that one might take a different view of the repeal of the legislation itself from the point that particularly concerned you, which was the issue of directives under it.
Well, exactly. So they say in their letters, and I think that this is where the judge does go beyond actually what the defendant said in their correspondence.
I'm not understanding this, but I understand you to be making a distinction. You asked for three things, something like this in the beginning, from memory. One of them was to repeal it. One of it was not to issue any directions. But the point you're making at the moment is that the significance for you on a day-to-day basis of the threat of issuing directions
was a real infringement, continuing infringement of Article 11.
Right, so that even if one might say that at a doctrinaire level, the government was always going to get around someday to removing this legislation, you can point to the fact that there was an actual real-time issue for you of being vulnerable to particular directives.
Exactly. So we were potentially vulnerable to work notices. We also had seen
They're
this.
called work notices.
So the work notice is the
Yes,
notice that says who is subject. So
Right,
who has
thank you,
to
I've
turn up and if it goes, if they don't go past the picket, you lose all your immunities and it goes wrong. So we had also seen in this litigation, the day before the acknowledgement of service was due to be filed, we received a letter in relation to the Heathrow strike that said, for the dates you've just given us, we're not going to give you a notice.
Sorry,
We're not going to give you a work
when
notice.
was this?
So that will be April 2023. We'd had a promise limited to the Heathrow dates. And as Mr. Skinner said, quite a lot of the government's defence was that we couldn't show, they said that we couldn't show that there was an Article 11 issue with Regulation 3 because we couldn't show that it would infringe Article 11 in all cases. And actually there hadn't been any of these notices, so what were we worrying about? But the existence of Regulation 3 in the background was always there as a chilling effect for us, we say. And we say that it went beyond the scope of the power in the Act itself because it was set at a level of 100%, no less effective than anything else. So what was a game changer for us in terms of the reason why we asked for what we did on the 9th of July promised never to use it was because that would make a substantial difference to us, such that we wouldn't need to have a fight in November on the dates of the substantive judicial review, because we had a promise that was sufficiently clear, precise, and devoid of relevant qualification, that if actually government did turn around and say, oh, actually, we've changed our mind and we're going to do it, it was not only in a letter from the minister herself, but it was also sent into court attached to a consent order. So we had a much, much narrower dispute if that came up. So it was so that was what essentially was the comfort, such that a notice of discontinuance could be filed. But we said, with the usual, because we've got what we were asking for, that's what made the real difference to us. And we say, in the fields of commercial litigation, where often there's very, very complicated issues about who might win, but the cases settle all of the time, if you actually get what you're asking for, the starting point is you get your costs. And that creates commercial certainty across the board, and it's always created significant certainty across government. I do cases on both sides, and there are cases sometimes where government decides, actually, we're not going to do the policy that's currently under challenge, but if it's after the claim has been issued, and unless you can show that the reasoning is entirely unconnected, and that means disclosing the ministerial submissions. If you're conceding a case because, for instance, the SPAD says, it would look really bad to have the disclosure of the ministerial submissions in open court, still sufficiently connected with the litigation, the costs in the usual position are granted. So what is being argued for is a very substantial departure from the usual position we say. This principle 6, where not clear who would have succeeded, the claimant will only be considered successful if they got what they were looking for because of the legal merits of the claim. That's simply not what the cases decide. There's nowhere in the cases that decide it. The closest is Khan, but in a passage that says this is not a general principle, and then has a paragraph 50 that says this is not a merits contest. And on the law, we say that Lord Justice Singh, in his two judgments, ZN and Khan, completely correct as to what the actual test is. What does causation really mean? And it's judged at the time of the issuing of the claim. They need to do that in order to vindicate the claim. Answer in this case, yes. We can say you can check this against Mr. Justice Fordham. He's not in the not in the Court of Appeal, but it has very compendious knowledge of the law in this area and doesn't look at it in that way whatsoever. Principle 7, that there's no principle that acceptance by the defendant that a decision challenge was flawed is a separate basis for the costs. So we say that the defendant's got this the wrong way up. Barter says that it's for the defendant to show entirely unconnected. Lord Justice Singh says entirely extrinsic. This is a very familiar concept to anyone who studies or anyone who practices in discrimination law. If you have a mixture of reasons, but one of the reasons is the thing that you're not allowed to do, you're still saddled with it. Principle number 8, in determining the causative link, the defendant accepts that it's for them to explain what was the cause and accepts that the explanation can be properly scrutinised. That's paragraph 63 of Barter. But principle 9 was it doesn't follow that evidence is required. Now, Mr. Justice Fordham disagrees in paragraph 17 of City Portfolio. And in my submission, actually, if you read Lord Justice Pell in Barter fully, he's saying there needs to be scrutiny. Lord Justice Males in Parveen suggests that what you don't want is a whole mini trial, particularly on the unlawful delay cases, because actually an unlawful delay, that would actually, on the legal issue, be trying the legal issue. Because you'd be looking at exactly who was where on the list, you'd have sensitive personal data to do with completely other different people. This case is really, really different. This is closer to Wolverhampton, where we did have disclosure, there was disclosure of the ministerial submissions, if you read paragraph 5 and 8 of Mr. Justice Fordham's decision really carefully, and he gives them very considerable scrutiny. There was Mr. Lord Justice Males in Parveen says again and again, you know, I'm not establishing general principles. You know, M and Croydon is the case on this. We say that there's no assistance to be gathered, particularly from Mr. Justice Swift in the IX case, save that it's a much longer decision than that of His Honour Judge Jarman, again running to several paragraphs, careful consideration of exactly what was an issue in the case and all of the case law and where there was disagreement between the parties as to the right test. We're not saying that there necessarily has to be affidavits, but we are literally blank as to what impact PCS's position in relation to MSL regulations on Article 11 had in relation to the timing and the giving of the particular promise that's word for word what we asked for in the 9th of July letter. Mr. Skinner says that the letter was sent to other unions in border force. Of course it is, because as soon as it's sent to us, you know, border force is a very small place. PCS knows prospects. Lots and lots of people who work in border force all know each other. It would be impractical to have the same letter that was sent to us, not sent to other unions in the same workforce simultaneously. There was industrial action from PCS. I can't recall whether there was anything to do with prospect. But the industrial action was to do with the new rotoring arrangements, which would affect members of other unions as well. So it can't be assumed that just because a letter is said to have been sent to other unions in border force, that affects the timing and the promise that was specifically given, or that it was prompted for such an express promise to be made because of our letter of the 9th of July. But given that we had no other response to the 9th of July letter other than this landing in our inbox in early August, we say that the burden is on government to show that it's not to do with the litigation, and that they, in the material that they decided to submit to the judge, there wasn't actually anything that went as far as the judge himself said, in terms of it hadn't been said by government that the letter was not sent because of the litigation. It was said that it wasn't sent because of the merits, and what's said is that the act wasn't being repealed, but the promise not to give any work notices, there was nothing said about that at all. We also say that it wasn't clear from the submissions of government that they actually accepted this as a M and Croydon number 1 category case, and we can see that in all our submissions. Principle number 10 was pretty similar. Is in terms of what is sufficient, the letters from solicitors and counsel can be enough. There may be cases where, because of the nature of what exactly has to be redacted, I'm not saying that that can never, ever, ever be done, but historically this is a situation where with big politics you've received ministerial submissions that so that the claimant can assess what the causal connection has been. And the 11th principle is that where the claimant seeks to go behind what's said as the explanation, that the defendant's position has to be accepted. And we say that that's the defendant has rather put their case higher than usual on that point. In their skeleton argument, they rely on the case of FDA and the case of Sophia. And what those cases say is that judicial review is not a jurisdiction that generally hears cross-examination, but it considers the documents. And we say here, we haven't actually got any of the documents, we haven't got the ministerial submissions. So we've got some very limited statements that don't go as far as the legal test in this that has to be surpassed, entirely unconnected. And that does allow us to ask the question. We did ask the question, the judge didn't engage with that question. The judge simply said this case is settled for, it has become academic for political reasons and not because of the claim, full stop. And that is all that we got. So those are my responses to the 11 points. I think I've covered the other factual points that I was planning to make in the course of those. Can I just check with those behind me? That, all good from behind me. That's a lady.
Well, we're very very grateful to both sides for your submissions. We will take time to consider them. We'll send out a draft judgment in the usual way. You know what I'm going to say next. The draft judgment is sent out not for the case to be re-argued, but for correction of any obvious factual errors like dates or citations and that sort of thing. The contents of the draft judgment are confidential to the parties, and that is those who need to know, either on the PCSU side or in the Home Office, and the legal teams, not for general publication until the judgment is formally handed down by being promulgated on the National Archive website. Thank you very much for your assistance.
All rise, people.